All persons having business before the Honorable Associate Judges now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and its honorable court. This honorable court is now in session. Please come to order.
Good morning, everybody, and welcome to this virtual session of the District of Columbia Court of Appeals. We have 3 cases on this morning's calendar, and the first one is number 21 CV 79, National Rifle Association of America versus JAMS, Inc. Whenever you are ready, counsel, and those who are not speaking, try to remember to mute yourself.
Thank you, Your Honor. My name is Philip Furia, and I represent the appellant, the National Rifle Association, in this matter. I would request 3 minutes to be reserved for my rebuttal argument.
Thank you.
On this appeal, the appellant, National Rifle Association, asks this court to reverse a ruling by the trial court, which granted a motion by JAMS, the defendant, to dismiss the NRA's breach of contract claim. This breach of contract claim was filed because JAMS failed in its obligation to provide the NRA with an independent and competent arbitrator for an arbitration proceeding the NRA had with another party. JAMS did provide an arbitrator, but after the arbitrator and the arbitration proceeding was underway and significant funds were spent, significant time was spent.
Counsel, can I ask just a threshold question? In the record, you include the disclosure forms, and you say that that is the contract that was executed in December 2019 that you're saying was breached. And I'm wondering, does that contract itself contain any sort of dispute resolution clause or arbitration agreement or choice of law provision?
No, that one that would actually govern this contractual dispute, the answer is no.
Okay.
I thought that was the premise of your argument, though, was that you had a separate contract with JAMS to provide you a fit neutral arbiter. And so I, like Judge Ali Khan, I was looking in the record for that contract.
Correct.
And I don't see it anywhere.
Right. So if you take a look at the record, and I can point you to the page, it begins on A34, and I guess it goes through A46. This is a memorandum and a confirmation of arbitrator selection. It is signed by an individual from JAMS. It's also signed by the NRA, and it is signed by an individual representing the NRA's counterparty in the arbitration over at Winston and Strawn. Again, these are the papers.
Specify any sort of law that governs this contract.
That's right.
Nor does it specify sort of the type of arbitrator that you are contracting for, right? I mean, it seems like the key document is the engagement agreement and cancellation policy, and that's really seems to be about billing and scheduling. The preceding page in the record talks about arbitrator selection, and that talks about a preliminary deposit and confirming Judge Neville's appointment, and references the enclosed engagement agreement, but the engagement agreement doesn't reference this document. I mean, I'm just trying to figure out, maybe this is a merits question about where this breach of contract claim is grounded, but it also seems related to your claim that this shouldn't be arbitrated and that there shouldn't be any arbitral immunity, because you're saying, well, this is just a separate, as I understand your claim, and maybe I misunderstand, you're saying, oh, well, this is just sort of an administrative matter. We contracted for, this type of arbitrator, and we didn't get that widget that we contracted for. That's what I understood you to be saying. I just don't even see as a factual matter that that's supported by the record that's before us.
Understood. So and this is based on both the complaint, which is to be taken as true at this time, and also the documents, which are in the record. But our argument is that the NRA contracted with JAMS to provide a competent and appropriate arbitrator. JAMS does not dispute that it had an obligation to provide us with a competent and appropriate arbitrator. And I will allow my learned adversary or opposing counsel to correct me if I'm wrong, but there is no argument that this particular claim was the claim that the NRA has filed was supposed to be arbitrated. The question is whether or not the claim is precluded by arbitral immunity, and whether the arbitral immunity that exists in whichever body of law applies here would apply to not only arbitrators, but to arbitral organizations.
And so here's my thought. So if the contract that you put in the record, which is about the selection and disclosures and all of that, doesn't itself contain any kind of choice of law provision, we look to the contract that was underlying this, the NRA contract, and that says that the arbitration shall be governed by the FAA. And so this now is a dispute arising out of that arbitration. And it seems like then, and maybe you'll disagree, but then the FAA applies to that. And then it seems like the next step is that under the FAA, there is this doctrine of arbitral immunity. Is that how you're thinking about this case?
Respectfully, I would disagree with that characterization. So a contract was entered between the NRA, Winston and Strawn, and JAMS. Some aspects of that agreement are memorialized in writing in those documents in the record, and they are buttressed by an additional understanding as to what the parties were asking JAMS for. And it does not tie back to the agreement between the NRA and this individual whose name I won't mention, because JAMS wasn't a party to that agreement, nor was Winston and Strawn. So we're talking about an agreement which arose in 2019. And you're right, perhaps there is a choice of law question that arises here. But if we take a look at the choice of law analysis in this district, it's an interest analysis. Okay, this is a contract dispute. Those are governed by state law. And this is a case that was filed in the District of Columbia about an arbitration that was supposed to take place in the District of Columbia.
So let me ask you about that.
Sure.
In the arbitration agreement, it says that the place of arbitration is Fairfax, Virginia. So how is the arbitration supposed to take place in the District of Columbia?
Well, in our complaint, we allege that ultimately the determination was made that the arbitration was going to take place at JAMS's offices in the District of Columbia. To my knowledge, JAMS does not have an office in Virginia. So again, this is an arbitration that was going, again, in the complaint, and it's to be taken as true at this phase. The arbitration is going to take place in DC. It involves JAMS's DC office. It also involves DC attorneys in Winston and Strawn's office. So if there's a choice of law analysis, our position is it ends up with DC law applying, but we don't even get there. And here's why. JAMS never argued that the law of a different state applies. And the trial court, and I get it, this is de novo review. The trial court said that DC law does apply. We just think that the trial court applied the law incorrectly.
What you said,
like
JAMS didn't argue that DC law didn't apply. Sorry, can you explain again? Because I thought JAMS did argue that federal law applied.
Well, right.
And actually made something of a preemption argument, although maybe not quite as clearly as it does on appeal.
Right. So it's not that JAMS didn't argue that DC law does not apply. What I'm saying is in a choice of law analysis, again, concerning a breach of contract case, we're trying to determine which state's law is going to apply. So let's talk about the FAA.
Choice of law just wasn't litigated below, was it?
It was not. It wasn't raised.
Full stop. So, I mean, if it got to that, would we reach that for the first time on appeal? It seems like that would be better addressed on remand to allow the parties to litigate that. We don't usually take up new legal issues that haven't been litigated in trial court.
Sure. So whether or not the choice of law was litigated, I would say no, but was it decided? The answer is yes. If you look at the trial court's decision, which is on appeal, trial court specifically
the trial court's decision leaves a little bit to be desired, right? I mean,
I agree.
It says that DC law applies without acknowledging that JAMS has said that federal law applies, and without acknowledging that JAMS has conceded that DC law doesn't recognize sponsoring organization immunity. It seems
Correct.
like there was a concession below that the court just blows by.
I don't disagree with that, but what I would say is it's clear from the decision that Judge Rigsby in trial court was applying DC law, implicitly determining that DC law is applicable. That decision and that aspect of the decision was not appealed. But what I'm saying here is if we did this
would it need to be? I mean, they prevailed. They don't need to say, well, we prevailed for the wrong reasons. You appealed.
Right.
So, I mean, and now it's de novo review before us, and we could say, look at this order is, it's inadequate to say the least. And we don't know whether DC law should apply in the first instance because choice of law was never litigated below. So
absolutely
go back and do that, please.
Absolutely. And look, we can see there is no briefing and analysis on choice of law, but our contention is it would be a choice of law between DC and perhaps some other states that would be the other choices. Because I'd like to address for a moment the FAA. The FAA applied to the underlying arbitration, but the FAA doesn't speak to arbitral immunity. Arbitral immunity is
But it seems like most courts of appeals that have considered this question have extended arbitral immunity under the FAA. I'm thinking of the 1st, 2nd, 5th, 6th, 8th, and 9th circuits. So why shouldn't that be persuasive that there seems to be a pretty clear majority view that if we're in the world of the FAA, arbitral immunity does extend to JAMS?
Well, right. So I understand that. And if you take a look at some of the cases that were cited, there are some from the District of Columbia's federal court, that's Cherdick and Habliston. But, the question really is, okay, what is the applicable law in the case, right? Because arbitral immunity comes out of state law or in some instances, federal common law. But what applies here? This is a breach of contract case. So state law applies. If you take a look at the cases that JAMS cites to in Cherdick, the court was facing a claim under the Declaratory Judgment Act, which is federal law, and a claim under Maryland state law. If you look at Habliston, there's 2 declaratory judgment claims, a 1983 claim, and a claim to replace the arbitrator.
I'm more concerned with the Federal Court of Appeals cases than the district court cases, because those aren't even binding on the district court. So what do you make of the Olson case? That's a breach of contract claim that is held to be under the scope of arbitral immunity under the FAA.
Well, right. But in this particular case, we are dealing with an instance where the applicable law to the claim is the District of Columbia. And the District of Columbia has a specific statute. The council has already decided the law they want to apply to the claims in their jurisdiction. That was not at play in Olson. Here, the council has considered the question of arbitral immunity, determined that arbitrators are immune, and decided to exclude arbitral organizations like JAMS. And when you look at the legislative history, they were concerned specifically that arbitration organizations might seek immunity for actions that are not directly a part of the proceeding. And that's exactly what JAMS is doing here.
But if we go all the way down the chutes and ladders to get to that question, and we think, well, actually figuring out who the jurist is and whether they, should be recused, really is part of the decision making, then, if we take sort of a functional approach, do you think that the district's arbitration statute forecloses that type of analysis, right? Because the legislative history that you're referring to suggests that they don't want a binary analysis, right? Sort of an on-off, oh, you're an arbitrator, you get arbitral immunity. They want something more nuanced so that they can say, hey, just anyone who has the job of arbitrator, doesn't get the cloak of immunity.
Right.
So is that fair, right? And so then we could go through this functional analysis, which seems to be what the federal courts do too,
Right.
and say, well, functionally, this really is at least the bias claim that you raise, that the failure to disclose the connection with the Winston partner, that seems very much part of the arbitral, judging process. Maybe the fitness claim is a little bit different, but arguably is also part of the judging process too. No?
So I understand exactly what Your Honor is saying, and it's right. If the bodies of law, which would include arbitral organizations, did apply here, and obviously we disagree, if they did, we would still take the position that there's no arbitration immunity here, because we are contending.
That's not. I'm sorry. Maybe I don't think my question was all that clear. So let me rephrase it.
Sure.
I actually am saying, if we apply DC law, right? Is there room for interpretation there? Because I grant you that the district, in codifying the Uniform Arbitration Act, left out the sponsoring organization immunity provision, and had a little explanation for that in the legislative history, but that explanation is not, doesn't seem to preclude us from interpreting the statute to extend arbitral immunity where it functionally is appropriate. Do you agree with that? If we're looking at DC law.
Respectfully, I do not agree with that, and here's why. The council could have, if they wanted, added some caveat for the instances in which arbitration organizations can and cannot be immune. They decided to simply say and strike arbitral organizations from the statute entirely. They provided their reasoning, but if they were only concerned about this particular issue, they would have presumably found a way to carve that out. Instead, they removed arbitration organizations entirely. So in our position, in our contention, the only appropriate interpretation of the code is that arbitration organizations are not immune from suit.
Okay, thank you, Mr. Furia. I didn't hear you pronounce your name in the beginning. Can you tell me how you pronounce your name?
You said it perfectly. It's
okay,
Furia.
Your time is up, but you wanted to reserve some time for rebuttal, so we will give you some time for rebuttal. And Ms. McGregor, I think you're up next.
Good morning, Your Honors. Jessica McGregor for the appellee, and may it please the court. I do think that this analysis is straightforward, and it does start with the contract that governs the arbitration. After all, JAMS cannot provide an arbitrator in any arbitration proceeding without some basis for the arbitration itself. And in this case, there was an arbitration agreement. That agreement.
Can we look at the text of that agreement? I apologize to interrupt, but I just want to, try and be efficient in our questioning, right? The arbitration clause says any dispute arising out of or relating to this contract, right? And so this contract is the contract between the Winston client and the NRA. Said that shall be finally resolved by arbitration, right? That's an arbitration exclusivity provision, and then says the arbitration the arbitration of the dispute relating to the contract between the Winston client and the NRA shall be governed by the FAA, right? But here, what we have the NRA saying is, okay, look, yeah, we agreed to arbitration for the underlying dispute with the Winston client, but we didn't agree to arbitration with JAMS. There are lots of arbitrators out there. We could have gone with any other organization, you know. We chose JAMS because JAMS told us that they were going to provide us with a neutral fit arbitrator, and we thought those are the folks we want to contract with. And so they're saying you breached that contract. That's not the contract that's covered in the arbitration agreement. What's wrong with that analysis?
Well, I think that well, I don't want to say that it's wrong, but where I differ with it is, I think the starting point for any organization that provides an arbitrator is that there has to be a basis for providing that arbitrator. And that could be a court order, or it could be an agreement to arbitrate. And so that agreement to arbitrate, what we just looked at together, is the basis for JAMS provision of an arbitrator to the parties who signed on to this arbitration agreement.
Where is that in any of the materials that we've been provided, the JAMS engagement agreement? Right, where does it say we're only providing you with these services because you've been ordered to arbitration or you agreed to arbitration? I mean, presumably if the parties are coming to you and saying, hey, we'd like you to help us out. I mean, you know, theoretically, Judge Ali Khan, Judge Beckwith, and I could say, gee, this is really hard. We need an arbitrator to help us decide this. And we could come to you and say, help us figure this out, right? I mean, I guess I'm not understanding quite what it is that you're saying this extra layer of agreement gives. Like, obviously they signed the engagement agreement, so they're there willingly with you. But the point is they picked you, they picked JAMS because they thought JAMS was going to provide the best arbitrators in the business.
Yeah, but the arbitration that JAMS provided the arbitrator for was an arbitration that itself was governed by the FAA. And that is the basis for example, that would be, hypothetically,
does the FAA, I'm not familiar with the statute. Does the FAA say you must provide, you know, neutral fit arbitrators?
What the FAA does provide, there is a disclosure requirement under the FAA.
But that's not what the claim is. The claim is not that you failed to provide us with disclosures. The claim is you provided us with disclosures, but you hid bias. And you also provided us with a racist jurist who is not fit to serve. Does the FAA have a provision that says, you know, does that clarify that those qualifications are required, fitness and no bias?
Well, I think that just like any judge sitting in any matter, there's a disclosure obligation. And what this claim is about is a failure to provide adequate disclosures. That's what, you know, if you look at the allegations in the complaint, it's all about what was not included in the disclosures.
Well, it's part of the complaint about the bias, but certainly the fitness isn't about, I think the fitness claim is more, you never should have had this person on staff to begin with. You shouldn't have been shopping him out as an arbitrator. That's not a disclosure claim. That's, you know, sort of, you know, negligence in hiring almost, you know, and certainly they're pitching it as a breach of contract. We contracted for a fit arbitrator, right? I mean, hypothetically, what if JAMS provided an arbitrator who didn't have a law degree, right? And, you know, it was understood that all the neutrals had law degrees, but this person didn't. Would that relate to the underlying contract to arbitrate with the third party?
I believe it would. I mean, if the arbitrator failed to disclose that the arbitrator lacked a basic, lacked a law degree, I think that would be housed under the disclosure obligation.
So, Ms. McGregor,
But I get,
why does that make sense for you? So, I mean, JAMS is in the business of providing hundreds, if not thousands, of arbitrations. And so it seems to me quite odd that as a business practice, you would want the underlying arbitration agreement to bind you. So I take your argument to be this arbitration agreement says that it's governed by the FAA, so you get the protections of arbitral immunity under the FAA. If it had said this arbitration shall be governed by District of Columbia law, it seems that that could be a quite different answer on the arbitral immunity question. And so why would JAMS kind of roll the dice for what the parties underlying the arbitration agreement had agreed to, as opposed to having a form contract in its engagement that says any disputes arising out of this arbitration shall be subject to the FAA, district law, whatever you think, so you have a uniform kind of understanding of what rules of the road govern all of your arbitrations, as opposed to just leaving it to the roll of the dice of the parties underneath.
well, I think that really gets back to the fundamental national policy in favor of arbitration and, the uniformity of extension of arbitral immunity, not just to arbitrators, but to their sponsoring organizations.
It seems to me that if it gets back to the national policy, you would do exactly what Judge Ali Khan proposed. You would actually put it in your engagement agreement, right? But and not leave it to the vagaries of the terms of the underlying arbitration. But that also leads me to ask a factual question, which is there any allegation and anything in the record to indicate that you actually saw the underlying arbitration agreement before you agreed to arbitrate for the NRA and the Winston client?
I don't believe all of the documents that were that led to the commencement of the arbitration were part of the record. But there
whose
the
burden
allegations
is it
in the first.
Whose burden would it be to put those documents in the record?
Well, this is a motion to dismiss, so
right, but it's a motion to dismiss based on arbitral immunity. Isn't it your burden to show that you've got arbitral immunity? So to the extent that you're saying, hey, we relied on the arbitration provision in the NRA Winston client contract, wouldn't that be something that you would need to plead that you were aware of before you agreed to the arbitration?
The arbitration agreement was put into the record and we made the argument.
That's not my question. My question is the timing, your knowledge of the arbitration agreement, because you're here saying, well, look, that the underlying arbitration agreement was what we relied on when we agreed to do the arbitration. But I don't see any indication of that in the record.
Well, no, I think I'm saying something a little bit different. And I grant you that there isn't a document in the record that shows that JAMS was provided this particular agreement. What the argument here is that the agreement that the NRA and the other party to the arbitration agreed amongst themselves that the FAA covered all aspects of this arbitration, including disclosure obligations, and that where there is a claim that there is a disclosure that is inadequate, as is the claim here, that is covered by the FAA and the federal laws interpreting the FAA. And under those rules and under...
Let's say that South Dakota just has abolished arbitral immunity. I don't know what South Dakota does, but we'll just take that for the hypothetical. And this arbitration agreement is exactly the same, except for saying the arbitration shall be governed by the FAA. It says the arbitration shall be governed by South Dakota law. In that world, then, do you agree that you would not be entitled to arbitral immunity? Seems to me like the answer would have to be yes, because you're saying that the parties get to decide what applies to JAMS. And I guess that just gets back to my original question of, I don't know why that makes any sense.
Well, I mean, and I think that that is a fair question. And the reason I hesitate to answer is because the concept of judicial immunity and quasi-judicial immunity is founded on just basic common law principles. And I think that's, you know, in the Bradley case that goes back to like 1872.
Well, but
you know,
here, that it may be true that the concept is born of common law. But the District of Columbia has a statute, right? We've codified the rules for arbitration in the district, and we've codified arbitral immunity, and we've said it stops with the arbitrator. We don't have, right? The Uniform Act has a provision for sponsoring organization immunity, and we explicitly, deliberately, you know, not inadvertently, not accidentally, left that out of our statute. So now we have a statutory scheme, and the trial court was looking to the district law, and JAMS conceded that the district law doesn't have a provision for arbitral immunity. So if we're under DC law, where does that leave JAMS?
well, I think that if we're, I don't think we are under DC law, but taking that all the way out, assuming we were, I'm not convinced that that statute precludes the extension of arbitral immunity to an organization like JAMS. For one thing, the express language of the statute says that it's a supplement, the grant of immunity to the arbitrator, just to begin with. It says the immunity afforded by this section supplements any immunity under any other law. And the committee took out the language about sponsoring organizations. It didn't explicitly prohibit the extension of arbitral immunity to a sponsoring organization. The concern was about extending arbitral immunity to the organization for acts that were not a part of the arbitration.
And yet
I think that's where
explicit text, right? That if they wanted arbitral immunity for sponsoring organizations, they could have kept the text in, right, under the model statute. And then, you know, that text could have been interpreted in alignment with the FAA, right? And with the federal common law that has arisen around the FAA. But doesn't it speak volumes that they took it out? And it seems, you know, judges don't write laws. And so when something has been taken out and you're asking us to put it back in, that feels like judicial rewriting as opposed to interpretation.
Well, we're not asking you to put it back in because we don't think the DC law applies. And
so can we talk about that? Because I understand you recognize that there is federal common law out there recognizing organizational arbitral immunity. And you've made a preemption argument, but it's not clear to me that when you have a federal, I understand that if you have a federal statutory scheme that occupies the field, that can preempt state law. But if you have a federal statutory scheme that doesn't speak to a particular issue, and then you have federal case law adding on to the statutory scheme, is it clear that the federal common law surrounding the statutory law has equal preemptive effect, right? Because that's just judges speaking, right? That's not Congress.
Well, I think the way that the cases that have interpreted the FAA and have the courts that have faced these types of claims have determined that in order to support the national policy in favor of arbitration under the FAA, and considering that this was an FAA arbitration, that in order to support that important goal, arbitral immunity has to be provided to both the arbitrator and the sponsor. Otherwise, sponsors like JAMS and other sponsors of arbitration would choose not to sponsor arbitrations, and that would dampen and quell the national policy in favor of these sorts of arbitration agreements.
Ms. McGregor,
so
Do we have the full contract between JAMS and the NRA and the third party in the record? Is it really just the rate sheet and the disclosures? And if not, is that problematic?
No, I think that is the agreement. What has been attached as Exhibit A to both the original complaint and the first amended complaint, which comprises the disclosures and then the follow-on of appointment.
I also have a question about arbitral immunity. So let's say this arbitration takes place in DC, even though it seems like it's supposed to have taken place in Fairfax. Winston and Strawn's attorney walks in and slips on a banana peel and falls and breaks their leg. Can they bring a tort claim against JAMS, or is that also precluded by arbitral immunity?
I think that hypothetical, that is just a straight up, negligence claim or, premises liability claim that is not intimately connected with the arbitral process. The fact that it happened in an arbitration wouldn't make JAMS immune from liability for not, cleaning its floors.
And is that your answer under both the FAA and under district law?
Yes. Yes.
What if same setup in DC, Winston and Strawn lawyer walks into the conference room where the arbitration is going to happen with the JAMS arbitrator, and before it begins, they're getting coffee and they're just the Winston and Strawn lawyer in the room and the arbitrator, and there's some sort of alleged sexual assault by the arbitrator right before the arbitration begins. Would that be also just a separate tort not arising out of the arbitration? It's an action by the arbitrator.
Right. I would think so. Just like in the Forrest case, where there was not immunity extended to the judge who, in an administrative capacity, fired somebody from the employ of a court. That was not covered by immunity because that wasn't the judge acting as a judge. That was a judge acting as on behalf of an employer. So under your hypothetical, I don't think that is covered by immunity.
Okay, and so same hypothetical, but right before arbitration starts and the arbitrator, utters some sort of racist slur to the Winston Strawn lawyer, also separate from the arbitration?
I think that's getting closer to the line of something that's happening in the arbitral process.
Why is that different from the sexual assault?
Well, I think that it's possibly connected to the arbitral process if it's a statement that's made, in the arbitration itself.
It's before the arbitration begins. They're getting coffee. Racist slur is uttered.
I mean, that's possibly not covered by immunity.
But 5 minutes after the arbitration begins, same words, and that definitely is.
I think if it's on the record, something that the arbitrator says on the record, that's probably not actionable.
Thank you.
Thank you, Ms. McGregor. Mr. Furia, we'll give you 3 minutes.
Thank you very much. So I'd like to just touch upon the point that the court was making at the end of the appellate's argument, which is where do we draw the line, even under the FAA, for what is and what is not covered by arbitral immunity? Okay, we're not contending that JAMS is liable for something that happened during the arbitration, or even during the process of providing the arbitrator. We're saying that they, in one instance with regard to Mr. Grimm at Winston & Strawn, it is during the process of providing the arbitrator, but Look, the far more egregious issue here is JAMS had a person who sent a horrific, highly offensive, racist email to a member of the NRA's legal team on their panel for who knows how long, decades. He's a member owner of the organization.
Where does your contract say you won't have a racist arbitrator? I get that you have to have one who discloses and who can be impartial, and perhaps these horrific comments that he made gets you over that line, but it seems like I don't see anything in your contract that says his own personal views somehow come into play and make JAMS actionable.
Well, a person who holds the views that are expressed in the article, and I would encourage all of the court to read the article. Anyone who holds those views is not fit to serve as a jurist or as an arbitrator. And I think that
be impartial. I guess I'm trying to figure out, do you have two separate strands to your argument for why he's unfit, or do they really boil down to the same point, which is that he can't be a neutral because he holds these views. And the disclosure suggests that he is neutral when he's not.
Exactly. He should not have been on their panel holding these views. And I think that brings me to my next point, which is the FAA did not require the NRA to go to JAMS for this arbitration. The arbitration agreement between the NRA and the Winston Strong client did not require anyone to go to JAMS. The parties went to JAMS because JAMS is this organization that claims to be at the top of its class. So it was a separate agreement that was entered into after the arbitration agreement, well after. So it's a straight breach of contract claim relating to that agreement between the NRA, Winston and Strawn, and JAMS. Breach of contract claims are governed by state law, not federal law. So what the appellee is asking this court to do is rule that federal common law preempts DC statutory law concerning a breach of contract claim. That would be an unprecedented decision. And it's a decision that is not supported by a single case referenced within the appellee's briefing. So for those reasons, we ask that this court reverse the trial court ruling. Thank you very much.
Thank you, Mr. Feria and Ms. McGregor, for your arguments today. The case will be submitted and you may exit the virtual courtroom.
Thank you.
Good morning. Can everyone hear us? Mr. Lipper, I wasn't sure whether your dog was going to argue or not.
Unfortunately, it is not my dog. It is a dog of a former office mate.
Okay.
Who I don't.
The dog looks ready.
He would argue if he were available.
Okay. The second case on today's calendar is number 19-CO807, RASHOD, HOLMES versus United States. Whenever you're ready, Mr. Lipper, you both have 15 minutes per side.
Thank you, Judge Beckwith, and may it please the court. My name is Greg Lipper. I represent the appellant RASHOD HOLMES. I would like to reserve 4 minutes for rebuttal. At his trial, Mr. Holmes testified and argued that he acted in self-defense, and the basis for his fear of the decedent, Mr. Abel, was that a few hours earlier at the nightclub that night, Holmes and Abel had been in a fight, and Holmes testified that Abel had pulled a knife out of his right pocket and lunged after him, so that a few hours later, when he saw Abel approaching and threatening him with his hand in that same pocket, he actually and reasonably believed that Mr. Abel still had the knife and that his life was in danger. That defense didn't work, however, because the government stressed to the jury that no other witness saw Mr. Abel with a knife, and argued that there's no corroboration, no other witness saw it. You shouldn't believe Mr. Holmes. Without any other witness, there's no knife, and with no knife, there's no self-defense. And the jury at trial, agreed with the government. Since then, 4 witnesses have come forward, all of whom saw Mr. Abel with a knife that night, and most importantly, eyewitness D'Angelo Jones directly corroborated Mr. Holmes's testimony that Abel pulled out a knife during the fight inside the nightclub a few hours earlier.
Can I ask you about Mr. Jones? Mr. Jones is the one who was actually on the witness list. Is that correct?
That's correct. Yes.
And Mr. McDaniel was going to call him. And then there was a recess, but we don't really know what happened, right? What is the? Can you tell us what the record says about how much Mr. McDaniel knew about Mr. Jones's story and his view? It's sort of confusing. It does seem like he was going to call him, but he also says things about not recalling. Can you fill in the gaps there?
I will the best I can. I agree that Mr. McDaniel's recollection was rather foggy, but here is what we know. We know that Mr. Jones was on the witness list, and that after Mr. Holmes finished testifying, Mr. McDaniel asked the court for a brief recess because his next witness, who was Mr. Jones, he was having trouble. He said something to the effect of, "I'm having trouble with my next witness." They go for a recess. He couldn't find him. And Mr. McDaniel testified that he does not recall having subpoenaed Mr. Jones to testify. Mr. Jones testified that he was never contacted by Mr. McDaniel or a defense investigator, and that testimony is not rebutted. Mr. McDaniel says that he probably would have, if he had put Jones on the witness list, he probably would have discussed the testimony with Mr. Holmes before trial. But even Mr. McDaniel's sort of subjunctive tense did not extend to I probably would have talked to Mr. Jones in advance. So Mr. McDaniel didn't either say or even suggest that he actually spoke to Mr. Jones beforehand.
And so, Mr. Zipper, I'm a bit confused by that because, while some of the testimony was fuzzy, it seems like McDaniel, all these years later, knew what Jones would have testified to and describes it in detail about how he witnessed this interaction in the club. And so, yeah, I guess it seem sort of incredible, Jones's statement that he was never interviewed or never spoke with Mr. McDaniel if Mr. McDaniel knows all of this critical information.
But when McDaniel's testifying, he's being shown Mr. Jones submitted an affidavit. That affidavit was submitted actually in the original petition. So that was available to counsel and to Mr. McDaniel, even at the first hearing back in 2014. And so I believe he was basing his memory actually on reading the affidavit. And in fact, in 2014, and I think this is actually a very important point about not only Mr. McDaniel's memory, but his, whatever analysis he might have purported to have conducted, that in 2014, Mr. McDaniel said, when asked about Mr. Jones, potentially he could have, this is on page 42 of the August 29th, 2014 transcript, potentially he could have corroborated our testimony regarding what happened in the VIP room. But as you have said, I don't think that was much in contest. It wasn't in contest that there had been a fight between Mr. Holmes and Mr. Abel in the VIP lounge. That much is true. But it was very much in contest whether Abel pulled out a knife during that fight. And so when Mr. McDaniel is testifying in 2014 that he doesn't think Mr. Jones would have provided testimony material to a contested issue, that reflects even, even at the hearing, that he does not understand what Mr. Jones would have testified to. And in particular, Mr. Jones would have testified that Mr. Abel actually pulled out a knife.
Does it reflect that he doesn't understand what Jones would have testified to, or he doesn't understand the materiality of what Jones would have said, right? I mean, critical to corroborate Holmes's account that Abel is armed in the club, maybe even more critical to corroborate seeing a knife in the club than outside, because then you get into the complexity of figuring out, well, where did the knife go if he still had it when he's outside the club? But if it's inside the club, there's enough time for the knife to be put down or handed off. But it would give someone perhaps reasonable fear such that later when they have an altercation, they feel like they have to act in self-defense. But my ultimate question is, like, does it really show that he doesn't know what Jones would have said, or does it show that he doesn't understand the import of what Jones would have said?
That I think I think that's not clear, but I think that is not actually relevant to this appeal for two reasons. First of all, the trial judge actually did not make any finding or ruling that Mr. McDaniel had made a strategic decision based on his understanding of Mr. Jones's testimony. The trial court assumed, for the sake of argument, that his performance with respect to Mr. Jones was deficient, and it was undisputed that even if Mr. McDaniel had a perfect understanding of Mr. Jones's testimony, that he never subpoenaed him or told him to come to court. And so at that point, either he didn't either know or understand the significance, either that Mr. Jones saw a knife or the significance of his having seen a knife, or even if he did, he made zero effort to do the basic minimum to ensure that the witness came to court. And I think there's a good reason then why the trial court made no finding about a strategic decision and made no ruling that performance was not deficient, because there's no way to justify the overall conduct, including not subpoenaing the witness to testify with respect to a strategic decision. Where the trial judge went wrong, however, is in his conclusion that there was no reasonable probability that Mr. Jones's testimony would have affected the outcome of the trial. And I think the trial court made a couple of key legal errors, legal and logical errors. Number one, the trial court appears to have just misunderstood the importance of corroborating Mr. Holmes's testimony about what happened inside the nightclub. Again, Mr. Holmes's testimony at trial was not that I saw Abel swinging a knife at me outside the club. It was that I feared that the hand that was in the pocket a few hours later was going to pull out the same knife that he pulled on me earlier in the club. So in terms of, I think, as Judge Easterly, as you suggested a moment ago, the most important corroboration for Mr. Holmes was another eyewitness who saw Mr. Abel pull the knife out in the nightclub. If this were a sufficiency issue, perhaps it would have been more, or sufficiency of the self-defense issue, that perhaps it would have been more important to have someone who saw the actual shooting. But here, the question was, would the jury, what was going to make it more likely that the jury credited Mr. Holmes's testimony about what Mr. Abel had done inside the nightclub, and another witness with no apparent axe to grind would have gone a long way and would have prevented the government from saying no other witness saw a knife, therefore there's no knife. And that
can I interrupt you there? That this is going to broaden it a little bit beyond Mr. Jones, because I'm interested in your view of, like, how much can the trial court, in sort of applying a Strickland second prong prejudice analysis, basically say that there's a lot coming from the trial court here. Like, I think the jury would be skeptical of this. I don't think the jury would have viewed this as persuasive. I guess it's still a question of law coming up to us, but particularly with the, I guess the judge thought that Mr. Jones only talked about what was inside, and Mr. Sims and Mr. Spencer differed on the timing. Are these all questions of law for us? Because the trial court really makes it sound a lot like he's kind of looking at it for himself if he were a juror.
So it is both the deficient performance and the prejudice inquiries are mixed questions of law and fact and are reviewed de novo. I think probably the clearest statement of that standard is in the Cosio case, which we cite. throughout our opening brief, at least I think that's the one case where it talks about both the mixed question of law and fact and the resulting de novo review, although I think that's kind of both of those concepts are also sprinkled in other cases. And I guess I would put it this way, that and I say the trial judge, it was actually the motions judge because there had been a different trial judge, but the motions judge, his findings of fact about issues that are sort of incidental to the events that night are, factual findings. So his factual findings about, was a witness available to testify that day, or was he in New Zealand or something like that, or did trial counsel fall asleep in trial? Those are findings of facts that would be reviewed for clear error. But in terms of the prejudice analysis, the inquiry is not, the trial judge can't say, well, I do not believe this witness, and therefore I do not credit their testimony, and let the Court of Appeals review that for clear error. In the context of the prejudice analysis, ultimately the court is considering sort of what a reasonable and objective jury would have, might have done with this evidence. So,
I'm sorry, can I just, are you saying that sort of credibility assessment is never part of the trial court's job? I mean, sort of thought it was baked into why we have the hearing, right? Because we want the witnesses to testify so that the judge can hear them and evaluate them. Is your point that it happens at the deficiency stage? Like that's when the judge decides, okay, I don't think that this person is absolutely just making this stuff up years later. And so therefore the lawyer, I can at least assume deficiency in the lawyer's failure to call this person as a witness. But once they've done that's where that ends? Or are you saying you never make an assessment about credibility?
So I guess two things. So there may be credibility assessments, and I think they're more likely to happen in the deficient performance stage. Because there you're talking about, was the witness available? Did the witness come forward at the time? Was the witness contacted by an investigator? And those are the types of things that do turn on findings of fact and are reviewed for clear error. They're kind of incidental to the shooting itself, and they go to the procedural, for lack of a better word, predicates to showing ineffective assistance of counsel. Credibility evaluation and the reason for a hearing when you're talking about prejudice, I think there are some things that may be relevant. If the trial court noted, for instance, that every time this witness was asked a question, he sat and looked really nervous and paused for 10 minutes before answering. And given the way the witnesses testified, it is unlikely that the jury would have credited that witness. I think that's the sort of, it's based on having an in-person hearing, but it's even then though it is not, and even then that goes in ultimately to the application of the mixed question of facts to law that this court is reviewing de novo.
And isn't that effectively what the motions judge said about Sims and Spencer?
No, with respect to Sims and Spencer, he did suggest that he did think that the jury would not have found them credible, but he was basing that on really the substance of their testimony, not, for instance, they looked shifty in the stand.
But I'm looking at, I think it's Appendix 15. It seems like he says that he's crediting Mr. McDaniel, saying that he was not aware of Mr. Sims and Spencer. And that's what I take Judge Beckwith to be asking about.
So I understood. So I understood Judge Beckwith actually to be asking about the motions judge's assessment of in the prejudice analysis of how the jury would have viewed Sims and Spencer, whereas your question, in which there was a factual finding based on credibility, went to deficient performance, and in particular whether trial counsel had been told about Sims and Spencer before the trial. With respect to that factual finding, there was the motions judge was clearly erroneous because he simply misstated the actual testimony from Mr. McDaniel. Mr. McDaniel said he did not remember whether or not he had been told about Sims and Spencer, and the trial judge then found that Mr. McDaniel had said he was not told.
Back on that, it seems like Mr. McDaniel was giving sort of classic lawyerly response, which is to say, I don't remember that ever having these folks before me, but he stands there 10 years later, is not going to swear on a Bible that it never happened. He's just saying, I don't remember it, I don't recall it, and that the motions judge, in seeing that testimony and seeing how he's articulating it and seeing what his body language was able to draw from that the inference that yes, in fact, he was never made aware of it.
I think if he had sort of said it offhand once or twice and no one had followed up on it, that might be a reasonable inference. But the presence of lawyers, made it so that this very question, are you saying it didn't happen or you don't recall, was asked and followed up on. And so, and this is on page 55 of the August 29th, 2014 transcript, I think is where some of the key testimony is. So question, you couldn't remember whether or not you were told about Martell Sims or Kevin Spencer, correct? Answer, that's correct. And then there's a follow-up. You don't remember one way or another. I don't want to sit here and represent that it didn't happen when I don't have any independent recollection of it. So I think this very question, the distinction between you don't recall or it didn't happen, was put to Mr. McDaniel multiple times. And he answered clearly that he was not saying it didn't happen, nor is this the sort of thing that several years later, Mr. McDaniel necessarily would have remembered. He testified that he had handled, I think, more than 200 criminal cases and tried more than 50 cases. So there's no reason that he would necessarily remember each and every witness he was told about, potentially exculpatory witness he was told about. And unlike in most cases in which trial counsel would be able to consult their file and possibly say, yes, every time I'm told about a lead, I have a notes document, I write it down, and I'm looking at my file and I don't see it. Mr. McDaniel, for whatever reason, was unable to get his file from his storage facility. It's a little unclear exactly why that was, but it is, I don't think, disputed that he didn't have the benefit of it. And so, number one, he made it very clear, and it was sort of examined in detail, and that he was saying not that it didn't happen, just that he doesn't recall, number one. And number two, this isn't the sort of thing where if it happened, you would have remembered it, right? There was nothing especially unusual about the testimony such that nobody could possibly have forgotten about that 10 years later. And I think more broadly, there were a number of things that Mr. McDaniel didn't seem to have a great grasp on that you might have thought trial counsel would have. Even, when he's talking about the decedent, and he's like, I believe his name was Mr. Abel. I believe her last name was Donaldson. He wasn't, he did not have a photographic memory, I think, to say the least. And so it seems entirely plausible that, he wouldn't have remembered, especially, because he didn't follow up. I mean, one explanation for what happened was.
Can I interrupt and ask and I'm sorry for interrupting. What do we do, even if you're right that it's clearly erroneous to say, Mr. McDaniel never met or didn't know about these witnesses? What do we do? It's not like we have a record for the opposite. I guess we do. We have those, we have witnesses saying these things, but what's the theory by which Mr. McDaniel, would have found Sims and Spencer and called them as witnesses? Like, how do we, do you have to rely on sort of a duty to investigate and get out there? Or do we need a record showing, kind of like we have in Jones, he must have known about it because he had him on the witness list?
I don't think he wouldn't have had when the claim is failure to investigate and thus failure to put him on the witness list. I don't think that that latter thing is required. I think there is testimony from Ms. Spivey and then from Mr. Sims himself that Ms. Spivey told Mr. McDaniel that there were these two witnesses who were at the scene, of the shooting. And then Mr. Sims testified that he actually approached Mr. McDaniel in the courthouse, and then Mr. McDaniel told him he would call him, but never did. And so I think you can. And one thing about that point, by the way, I just want to make clear that the motions judge did not sort of independently discredit Ms. Spivey or Mr. Sims. He said, well, McDaniel said this, I credit him. And so he sort of discredited the other witnesses by implication, but there was no independent basis he identified to to doubt their credibility. And so I think you can piece all of that together with, you have these witnesses coming forward. He was told that there were two witnesses who had some information, who were witnesses who had some information. And had he contacted them, they would have told him what they testified they would have told him. I do think, however, that the court can bypass this whole question because D'Angelo Jones alone is sufficient to establish that Mr. Holmes, was given the ineffective assistance of counsel and was prejudiced, for the reason that with that corroboration, and especially given the many, many problems with the government's case at trial, the presence of a witness who directly corroborated Mr. Holmes's testimony about what happened in the nightclub, and that is what was the basis for his actual and reasonable fear that he was about to be, he was going to be stabbed if he didn't defend himself. That would have taken away the government's key sort of refrain at trial, which was no other witnesses, therefore no knife, therefore no self-defense. And Mr. Jones, there's nothing in the record that really would cast any doubt on Mr. Jones's credibility. He has no criminal record. He has sort of respectable jobs. He doesn't really even know Mr. Holmes that well. He had been in the marching band with Mr. Holmes's cousin, but had never socialized with him. So there's nothing in the record suggests Mr. Jones has an axe to grind. And, his testimony, I think, is pretty clear. The person he described is, I think, unmistakably Mr. Abel, given his size and his dress. And even the knife, I think the motions judge and the government suggested his testimony about the knife was vague, but it wasn't really, given that he was testifying about this, 11 years later. He said it could have been a knife or a blade. The government asked him, could it have been a bottle? And Mr. Jones was like, no, it wasn't curved. It was definitely, a knife or a shiv. I don't know that more was necessary. He wasn't being offered to appraise the knife. He was being offered to, test it, to identify it as such. And I
think Judge Ali Khan has a question.
Oh, I apologize.
Just getting talked over.
I apologize.
I apologize. I think I might be having an issue with my audio. So assuming we agree with you on, say, Mr. Jones, what do we make of the argument that we should still affirm or not vacate the CPWL claim? Do you think that's properly before us? And how do you think the legal analysis goes on that?
We are not. I don't think Mr. Jones is going to the. I guess I will see this. So I will say, first of all, this is not something we have briefed. To the extent that self-defense, a valid claim of self-defense, kind of provides a legal basis to have been carrying the pistol, that may be something that needs to be explored on remand on that particular conviction. But as a practical matter, what we are arguing here is about the murder convictions and the sort of charges resulting from the rejection of the self-defense claim. Like I said, to the extent there is a legal argument that when you use a pistol in self-defense, that sort of ex post kind of justifies the carrying of the pistol, that may be something to be dealt with by the motions judge on remand. But as a practical matter, Mr. Holmes has served his full sentence on any carrying a pistol without a license charge. So we're happy to have that considered on remand.
And thank you, Mr. Lipper. If my colleagues have no further questions, we will hear from Mr. Hahn.
Thank you, Your Honor, and may it please the court, Brian Hahn for Appellee of the United States. The trial court did not err in denying appellant's 23-110 motion in this case. I guess I'll start with what appellant was talking about, the bulk of the end of the argument with regard to Spencer and Sims. And I think that the trial court there did not err in deciding that Mr. McDaniel was not deficient in failing to investigate or call Sims and Spencer, because as the trial court found, that Mr. McDaniel was never informed of either of those witnesses and had no reason to sort of figure out who they were independently.
What is the court's basis for determining that he didn't know when really all he said was he didn't recall? Can the judge, is that a reasonable inference given, I understand, sometimes saying I don't recall that happening really means that didn't happen, but here it got kind of pushed in, they probed it further and it seemed to really mean, I don't know, it could have happened.
So I think it's important. We'll look very closely at Mr. McDaniel's testimony and the questions that are asked him. So on the first hearing, this is the August 29th transcript at 48. The question is, did anybody bring to your attention a person named Martell Sims? And he says there, I don't recall. And then the question then is, when you say you don't recall, do you have just no idea if anybody did or? And his response is, I don't remember any mention of Mr. Sims. And when asked again, can you explain what you mean by I don't remember? He says, this is the next page, I don't recall any mention of Martell Sims as a witness. And the same answer for Mr. Spencer, I don't recall Mr. Spencer being mentioned. This is the same transcript at 50. And I think that, it is certainly possible to reasonably interpret someone saying, I don't know, as I just can't say either way because I have no memory of the event. And it's also possible to interpret that as it didn't happen because I don't have a memory of the event.
Do you think the Mr. McDaniel's testimony at the first 23-110 hearing is in tension or direct conflict with his testimony at the second hearing?
I think that it's possible that at the second hearing, his memory there is, more eroded. Of course, the second hearing taking place 10 years after the trial, the first taking place, I think it's 6 years after the trial. And so I think it's highly likely that as time passes and significant amounts of time pass, that your memory of even important events like that erode. But there are these two interpretations of what he could have been meaning, and of course, saying something like "I don't recall that" is very different from saying "I don't recall that." And the trial court is there. The trial court's there, can assess the demeanor of Mr. McDaniel both at the first hearing and the second hearing. And what the trial court concludes is that Mr. McDaniel means the latter, or at least has sufficient confidence that he means the latter to make that factual finding. And that's the support in the record for it.
Mr. Hahn, the I don't recall is I don't recall anyone mentioning this witness to me, i.e. he doesn't recall Mr. Holmes mentioning this witness to him. Is that the scope of the I don't recall?
Well, I think it's any witness. Sorry, Your Honor.
But what about counsel's independent duty to investigate? What is there in the record to tell us what counsel did to go out himself and find witnesses?
There's not a lot in the record about that, Your Honor, but I do think that it is incumbent, appellant has the burden here. It's his motion. He's got the burden to show deficient performance. And so if the question is, was there a way that Mr. McDaniel should have reasonably found Spencer and Sims through investigation, appellant has made no claim other than he told Mr. McDaniel about it, or his mother did, that shows that Mr. McDaniel should have somehow found these witnesses on his own through some reasonable investigation. There's no line of investigation proffered here which says that he should have found them. And the trial court, doesn't quite explicitly discredit appellant's mother when she says she tells Mr. McDaniel about these witnesses, but he does say that even if she were credible, it wasn't very compelling. And I think that's sort of as close to a credibility finding or an adverse credibility finding that we got from the judge in this case. And the court, of course, clearly credits Mr. McDaniel's testimony and says that it was very credible.
Mr. Hahn,
yes.
I'm quite concerned about the Jones testimony, so I'd like to take you to that if we may.
Sure.
It seems like of all of the witnesses, Mr. Jones would be the most corroborating of Mr. Holmes because, Sims and Spencer say they see a knife outside the club. Mr. Holmes doesn't say he sees a knife. And so that his fear was because there'd been a knife pulled on him in the club earlier in the night. And so Jones's testimony directly corroborates that. And so it seems like the motions judge gave very short shrift to the impact of that in conducting any sort of Strickland analysis.
And I think that's because the trial court basically gives the testimony very short shrift because of the vagueness of the testimony. So this is, Jones testifies on November 16th of 2018. The transcript at 10, he says, when he gets into the club, there's some commotion. He says somebody is pulling out an object. And then he says, it's a knife, I believe. It was a sharp object. And, he's fairly clear that it is some sort of bladed object, not a bottle, probably a knife. And then when he's asked to describe the person who pulled out the knife, he says, the question is, can you describe the person who pulled out the knife? He says, not really. The only description I can remember, it was a heavyset, large guy. He was black. That's it. He had on white.
Didn't he say, wearing all white? Isn't that exactly the description everyone else gave?
We don't contest that the description is one that matches Mr. Abel. I think the question here then is, all right, is this description specific enough to actually say that it is strongly corroborative of appellant? If this were a lookout in a suppression motion, for example, I think the government would be, the government having the burden in that instance often puts on evidence that was the only person who fit that description. That's why the police had reasonable articulable suspicion, perhaps, to stop the person because of a tip or some other report.
But would this evidence be enough to allow Mr. Holmes to argue it in closing and basically combat the government's refrain that there's no knife, no knife, no knife?
Sure, I think it's certainly relevant, right? I think it passes the admissibility standard. I think that's not the standard here. The standard, of course, is a reasonable probability that the jury's verdict would have been different. And I think that the vagueness of D'Angelo Jones's testimony, both with regard to, all right, what was the object exactly, and then second, who was the person who was wielding it, I think that appellant could have made the argument. I don't think it had a reasonable probability of changing the jury's decision. And that's also...
Do you say that even acknowledging the real problems of the government witnesses? I mean, it seems like the government's case is not particularly strong here. The linchpin of the self-defense claim is that Mr. Holmes thought that someone had pulled a knife on him in the club. And here is the only testimony we have that corroborates that. And it seems like that is, perhaps if the government's case were much stronger, it might not factor into the prejudice analysis. But it seems like this was kind of a weak case on all sides.
I disagree with the court's analysis of the government's case. It's not the strongest case, but certainly there are two witnesses that see appellant shoot Abel from behind. And of course there is, the bullet comes in behind. Sorry.
He can shoot Mr. Abel. Mr. Holmes concedes he shot Mr. Abel. He explains that it's because he turned his head that this bullet ended up in the back of Mr. Abel's head. But both of those government witnesses had pretty strong incentives to put Mr. Holmes away, right? So we have the police officer who had shot him 13 times and was under investigation for that. And then you have Miss Donaldson, I believe, who had said all along that she had not seen the shooting until she was in a plea deal for some pretty significant drug activity.
So, I think that, of course, Christian Donaldson had had several issues with her testimony and the impeachment regarding that. I do want to push back a little bit on the officers, the impeachment there, because I think that, regardless of whether it completely defeats appellant's self-defense claim if he shoots Abel in the back of the head. And of course, the bullet entry, I think it's behind the right ear, is what is described in the medical examiner's testimony. And, we can argue about how reasonable it is for someone to turn their head so much that the camera probably doesn't show it very well, but that the bullet would enter behind their ear in the back of the head. But I do think Officer Maudlin, he is under investigation, or was, for shooting appellant. But, even his partner at the time, someone shoots someone. It doesn't really matter if they shoot them from behind or they shoot them from the front or what have you, I think a reasonable police officer still thinks that person is dangerous. And so if, his partner, and I want to get back to that, says, as he's chasing appellant, he also has his gun out because there is a shot that went off. Somebody got shot in the head, and appellant runs away from the scene, and they see him carrying the gun as he runs from the scene. And so, I think perhaps the jury took the impeachment as, it wasn't really Officer Maudlin. Officer Maudlin didn't really see appellant aim the gun at him later, and perhaps that's why the jury didn't convict appellant of the APO charge in this case. But I do think that, again, regardless of how appellant shoots Abel and the manner in which it happens, Officer Maudlin doesn't have a motive to lie about it being face to face or being from behind. And so really the evidence that appellant shoots Abel from behind completely defeats the self-defense claim. Even if Mr. Abel does have a knife, there's no reasonable way that someone who is with their back turned on you, or at least not described by appellant in this case, is going to hurt you in any way in that sense.
Mr. Hahn, we have precedent such as Byrd, which talks about, in the context of ineffective assistance of counsel claims, kind of the importance of corroborating a testifying defendant. And I think that case sort of suggests, it seems to be relevant to this case in the extent to which it suggests maybe imperfect testimony might be way more important in a case like this when there's no corroboration. Do you think that Byrd applies here?
Yeah, so I think Byrd does not, might speak to some cases, but not this one, because one of the major concerns, of course, that Mr. McDaniel testifies about at the first hearing is not putting on a witness who the jury could.
Oh, you are frozen, Mr. Hahn.
Question because the self-defense claim.
Mr. Hahn,
sorry,
you were frozen for a minute.
Yeah,
can we take you back to the beginning of your Byrd answer?
Of course, yes. I don't think Byrd applies to this case in particular because of the obstruction of justice charge that's levied against appellant. This is a case where he sends a letter to a witness saying, it starts with all she has to say is, and then describes what he wants her to say, and then ends with, burn this shit up when done. So I think that, Mr. McDaniel testifies to this, of course, at the first hearing, that if the concern is we don't want to put up anyone that might reinforce this idea that appellant is obstructing justice and is getting people to come to court to lie for him or to say something that is untrue for him, that this concern may override the idea that some corroboration or imperfect corroboration is better than no corroboration.
I'm sorry, I'm not following. So you're saying that is why it doesn't matter to bring Jones before the jury?
I think that's right, Your Honor. I think that
Jones doesn't have a connection. Didn't we just discuss this? He doesn't have a direct connection with Mr. Holmes.
No, I think, and my memory of the hearing is that he said he went to high school with Mr. Holmes, but I think
it's like high school with a cousin or something, but he doesn't socialize with Mr. Holmes. There's no indication that they're friends.
Well,
so I guess you're saying because Mr. Holmes had an obstruction of justice charge in addition to the murder charge, that took any corroborating witnesses off the table for him? Is that the government's argument?
I think it's entirely possible to make that choice, Your Honor, that any corroborating witness who, especially one that had such vague testimony that D'Angelo Jones did, like, oh, I couldn't really say this about the weapon, couldn't really say this about the person who had it. I'm just coming here to give you the story of a thing that happened. I think that vague testimony and testimony that the jury could question when coupled with this obstruction letter and the obstruction of justice charge is something that may dissuade defense counsel from putting on a witness, even D'Angelo Jones in this case.
And that sounds like you're making a strategic argument, not a prejudice argument.
I mean, I think it also flows into the prejudice, Your Honor. I think that, a jury seeing D'Angelo Jones's testimony also would think,
a jury seeing D'Angelo Jones's testimony and seeing that it's not precisely tailored and that it is maybe vague in some respects in a way that might seem reasonable after the passage of time, would necessarily discredit that. And so no harm here. That's the argument.
I think not only, I think that not only is the jury questioning D'Angelo Jones being there and testifying to this vague story, I think also the vagueness of the story itself. I think those two things in conjunction would lead the jury not to change its verdict. And if there are no further questions, I'd ask the court to affirm the trial court's denial of appellant's 23-110 motion.
Thank you, Mr. Hahn. Mr. Lipper, we will give you 3 minutes, and I wonder if I could ask you a housekeeping question at the outset, which is the transcripts of the second 23-110 hearing. They're not all designated transcripts in the and do you know if there's we finally have been able to get copies of I think the 1026 and the 1116 one did not come to us in a natural way. Yeah, go ahead.
I have them all and I requested and received all of them. I am happy to send one or more of them to the court.
I think we have them now. If not, we'll issue an order or something. But I just wondered, is there any reason they weren't designated?
I'm not sure what you mean designated. So I had to submit so I will tell you, I'm not off the top of my head. I can't tell you. I certainly made sure I had all of them. I would have done a combination of requesting them, or the counsel for the second motions hearing was my former colleague. So it's possible he had them already and gave me some. And so I can very easily figure that out afterwards, but
that may be the explanation. I just wanted to make sure it was okay to docket them. Get them
I certainly have no objection to that. And yes, I certainly, through the combination of whatever requests I needed to make and whatever my former colleague had, sort of made sure I had every transcript. And so I have absolutely no objection to docketing them or otherwise.
Okay, thank you. And sorry for the diversion, and you can pretend we're starting at 3 minutes again.
No problem. And I wanted to pick up where Mr. Hahn left off, because to the extent there were questions about Mr. Holmes's credibility, generally, or with the letter that he sent to Ms. Donaldson, that made it more important, not less important, that there be corroborating testimony from other witnesses. And, certainly Mr. McDaniel mentioned other witnesses in his opening statement and put witnesses on his witness list. And so if the claim is that any corroborating witness would have been per se detrimental because Mr. Holmes was so toxic that the jury would have assumed any corroborating witness was lying, then, Mr. McDaniel, would have not named any other witnesses, and presumably would have just thrown, Mr. Holmes at the mercy of the court. And then more specifically, Mr. Holmes was in custody the entire time. Everything he writes or says to anyone other than his lawyer is going to be monitored. So the ability for Mr. Holmes to, secretly send a letter to D'Angelo Jones at any point saying, here's what you should say and here's what you should not say, and you want to make it look kind of half specific and half vague, I think there would be some record of that or some evidence of that if it had happened, number one. And this also replicates is in at least the same neighborhood as another error that the motions judge made with respect to Mr. Jones. One of the reasons he said there was no prejudice from the failure to call Mr. Jones was, he said, quote, this is on A18, in the appendix. At trial, the jury apparently discredited Mr. Holmes's testimony that he felt he was in danger when he shot Mr. Abel. But that's the whole point of having a corroborating witness, is that if there's a corroborating witness, that made the jury, not only is the jury can rely on Jones's testimony, but it also made the jury more likely to credit Mr. Holmes's testimony. As to the vagueness suggestion, I want to push back on the vagueness. I mean, it's 11 years later and Mr. Jones doesn't know Mr. Abel, but he described a large, heavyset man with wearing white. And if the case turned on, if the government had argued a trial, well, if it was a knife, it would have been self-defense, but it was a box cutter or a shiv. And so that wouldn't justify a shooting. That would be one thing. In other words, if there was something at trial that turned on the make or model of the knife or knife-like object, that would be one thing. But that wasn't what was going on at trial. The argument was there was no knife, not there was no knife, it was a box cutter. There was no knife, there was no sharp object in his hand at any time. And so
but isn't one of Mr. Hahn's suggestions that maybe it's so vague we don't even know that that was Mr. Abel?
But I think, you know, I think it would be quite a coincidence if there was another heavy-set man wearing white who was getting into an altercation at the nightclub at around the same time and pulling out a knife or knife-like object. There was no testimony about another fight or another person with that description and clothing. And even the government in its opposition brief does not dispute, and I think even here did not dispute that was Mr. Abel. I also want to note, and I think this kind of dovetails into the questions about the weaknesses in the government's case, that Ms. Donaldson not only had obvious motives to lie, but she too was vague on some key details. So in her testimony, this is on August 25th, 2008, how close to the defendant were you when you saw him do this? A few feet, I guess, I don't know. And question, and what did he shoot Jay with? Answer, a gun. Question, was it a handgun? Answer, I don't know. This is the government's star witness and can't tell you anything about the gun. And this was a year after the incident, not 11 years after the incident. More broadly, the problems with the government's case were not only that both the officer and Ms. Donaldson had motives to, or had skin in the game, for lack of a better word, but they too not only contradicted each other in material respects. Jones said, Officer Maudlin said that Abel was walking away from Holmes. Donaldson said he was backing towards him, but Officer Maudlin's testimony is also inconsistent with that of his partner, because they were standing very close to each other. In fact, his partner was actually in front of him and would have had a better view, yet his partner didn't see anything, didn't see the fight and didn't see the shooting. And Maudlin, standing behind his partner, claims to have seen everything. So there were plenty of reasons of contradictions, of vagueness for the jury to have had doubts about the government's case, especially if there was a witness to corroborate Holmes's testimony. And then one final point about, to the extent Mr. Hahn is suggesting that the sort of jury would not have believed Holmes's testimony that Abel kind of spun at the time of the shooting, hence, resulting in the bullet entering where it did. The government did not present any rebuttal testimony from from an autopsy witness or from a physicist or from anyone else saying, no, it's impossible that he could have spun that way or that the bullet would have. And so that was not Holmes's testimony. I mean, it's possible the jury wouldn't have to accept it, but there was no conclusive or any really scientific refutation of it, as I would imagine there would have been if it was, so easily rebutted. So I think all of those things, I see my time has expired, so unless the court has any additional questions.
Okay. Thank you very much, Mr. Lipper and Mr. Hahn, for your briefing and your arguments today. We appreciate that. And we'll take the case under advisement and you can log off and exit the virtual courtroom. Thank you. Good morning, everybody. Can everyone hear okay?
Yes, Your Honor.
The third case on this morning's calendar, number 18 CF 738, 18 CF 758, 21 CO 4, and 21 CO 46 is REYNAUD Cook versus United States and Don Fitzgerald Hancock versus United States. I believe we granted a motion for more time in this case, and please correct me if I'm wrong, but I think it's 25 minutes per side now. So I don't know whether Mr. Day or Mr. Schmidt is starting, but let us know how you plan to divide your time.
This is Mr. Schmidt, Your Honor. I'm going to start today, and Mr. Day will go second.
Thank you.
Okay, may it please the court, Paul Schmidt from DLA Piper on behalf of the appellant Don Hancock. And let me just, I just want to apologize to the court from the outset. I'm a little under the weather today, so I apologize for any coughing or anything like that during the presentation.
Thank you.
And I believe we have 12.5 minutes for Mr. Hancock for argument. We're going to reserve 1 minute for rebuttal. As the court is well aware, Mr. Hancock has raised 4 issues in this appeal. I want to spend most of my time today focusing on the Confrontation Clause niqab issue / the 23-110 motion. Those 2 issues sort of go together. If I have time, I'll get into the other issues, but I want to focus primarily on the Confrontation Clause issue. It's before the court today. Mr. Hancock's Confrontation Clause rights were violated at trial here because the main witness for the government, Miss Alicia Everhart, testified wearing a full body and almost complete facial covering called a niqab, which is a religious garment worn by certain faiths. The court committed plain error by failing to recognize that this was a Confrontation Clause violation and by not conducting a factual inquiry as to Miss Everhart's religion and her religious beliefs, and then compounding the error, trial counsel failed to object, rendering it ineffective assistance of counsel as to Mr. Hancock. Now, the Confrontation Clause requires that, I'll start with the Confrontation Clause violation itself, because we need to prove that in any event to get the 23-110 violation. But there's 2, I just want to emphasize, there's 2 avenues of relief here. One is his violation of his Confrontation Clause rights at trial, and then separately, the ineffective assistance of counsel motion, which is based on that violation of Mr. Hancock's Confrontation Clause rights.
But can I interrupt and just ask you if you concede you're jumping through the plain error hoops, do you have to show, basically settled law in our jurisdiction on this issue? And I believe I read in your brief somewhere that there really isn't a lot of law on this.
Yeah, the settled law, I believe, Judge Beckwith, goes to the issue of the 23-110 motion. I'm happy to address that now, or then it's purely.
I'm more thinking about the plainness prong of plain error review.
Right. Our argument is that this was plain error because the minute that Miss Everhart walked into that courtroom wearing this garment, it should have been clear to the trial judge as well as counsel, but again, that's separate for the 23-110 analysis. But with regard to the plain error, just of the Confrontation Clause violation, it should have been clear to the judge that this was problematic.
Mr. Schmidt, I hope you hear me. I share Judge Beckwith's concern under plain error because it needs to be an obvious error, and where there's no case law from the Supreme Court or our court on this question, doesn't that mean that I for sure you can't meet the test?
I will concede, Judge Ali Khan, that there is no Supreme Court precedent on this issue, and there is no DC Court of Appeals precedent on this issue. I will grant you that. But if I could, I can take you through the case law that doesn't.
It doesn't seem even to be any appellate case law. I mean, if I recall correctly from reading your briefs, it's a smattering of trial court decisions, none of which seem really directly on point to this issue. I can't remember the name of the case, but there's the one case where they talk about wearing a hijab or a niqab as a disguise, but not because of religious reasons. So it's really hard to find purchase for a plain error argument.
Well, so I will, again, Judge Easterly, I will grant that there is no precedent in this court or from the Supreme Court. I can't argue that there is. The case law that is out there, if I could just take the court through the cases to explain what our position is on those cases and why this should have been abundantly clear to the judge. There's a dichotomy, I think, between the cases that we raised and the cases that the government has raised and that the trial court relied upon during the 23-110 motion. And that is that in cases where there's a facial covering of some sort, whether it's sunglasses, whether it's a wig, whether it's a false beard, or whether it's something more dramatic or radical, like what we had in this case, or the Romero case in Texas, for example, there was a case where a witness had their collar pulled up over their mouth and a baseball cap pulled down and sunglasses where you virtually couldn't see their face at all. The Ali Mehmedi case, which I think Judge Easterly you referenced, is the case where the undercover officers were wearing or proposed several disguises to protect their security in court, and the court ruled that wearing a niqab was not satisfactory in terms of the defendant's confrontation clause rights. There's a dichotomy between the cases that we cite, Ali Mehmedi, Romero, and Ketchens, I think is the other case, where you have someone's face fully covered or almost fully covered, like Miss Everhart's was. I mean, you could just, there's no dispute that the only thing one could see if one were in that courtroom was her eyes, and that was it. There's a dichotomy between the cases that say that essentially near full facial coverings, that does not satisfy the face-to-face requirement of Maryland v. Craig, versus the cases that the government and the court relied on, where you have some sort of covering to be sure, but nothing on the level that we have here. So sunglasses, a fake beard and a wig, dark glasses, things of that nature. I have to say, hindsight is always 20/20, of course. But I think the minute that Miss Everhart walked into the courtroom, actually, let me back up. The minute that it was previewed to the court by the prosecutor that she would be testifying wearing this garment should have raised some signals as to what should have been done with regard to a factual inquiry.
This is an issue for sure. But I'm just wondering, do you have a single case that suggests that where there is no obvious case law that controls us, that the error can be plain or obvious under the current law?
I don't, Judge Alicon, I don't have a case that says precisely that, no.
I mean, I guess what I hear you saying is that, or I see the argument in two parts, right? Like, I take your point that once a witness walks in with their face obscured in some way, perhaps that should prompt some inquiry. But I think, don't you need to go a step further to persuade us what the outcome of that inquiry would be to prevail in this case, right? Because, and then that seems like a much more complicated question that's very fact-bound. And in this instance, where there's the assertion of competing First Amendment rights, there might be some balancing that needs to be done. And so it's just very hard to get there, for sure. Maybe the better practice is for any party who's sponsoring a witness whose face is obscured should have an obligation to, file a motion in limine before that witness takes the stand, right? And maybe a trial judge, should have an obligation to have some sort of hearing before allowing that witness to testify to ensure that everyone's rights are fully recognized. But what the outcome of that would be, because it seems like accommodations are made, and that's what the range of decisions reflect for witnesses who are in some sort of protective program, for child witnesses. We don't have just a very bright line rule, even though we have kind of a basic principle that we adhere to. So what's your response to that?
Oh, yeah, I think I can answer that and actually reconcile it with Judge Alicon's question. I think we focused so far today on the issue of whether there's a case for plain error from a plain error perspective that says you cannot do this, whether it's from the Supreme Court, this court, or even other DC precedent. So there is no such case, but we do have Maryland v. Craig, which says that face-to-face confrontation is required unless there is a religious policy overriding, or excuse me, strike that, unless there is a public policy that overrides that face-to-face requirement. I believe the exact words of Craig are that it's a preference if you satisfy the other two prongs, which is, satisfaction that there's a public policy, and that there's no prejudice
Right, but just to cut to the chase, I mean, why couldn't it have been possible that the witness walked in to the courtroom and just the general assumption was, this is a person who's expressing their religious beliefs. Obviously, the public policy exception of Maryland versus Craig is satisfied, and so we move forward because no one objected, right? And so to say that that is plainly wrong, it's just, I'm still struggling as to how to get there.
Because the trial court, Judge Easterly, should have conducted a factual inquiry as to her faith. The only evidence in the record as to her religious beliefs were that she said that she wore it sometimes, which, I mean, lends doubt to her religious beliefs. If she had said, yes, I wear this all the time and I'm wearing it today, that would be one thing, but she said sometimes. So there's already a question from the record as to whether or not she does this all the time or how devout she is. And the evidence that the government points to in its brief, or what it claims to be evidence, is the prosecutor's statement previewing this to the court, saying she's going to come out here, she's going to be wearing this niqab, she has found religion since the incident in 2007. That is not evidence. So really all we had in the record was a doubt as to what her beliefs were. And I just want to emphasize, Judge Easterly, I believe it was you talked about the child protection cases. Craig certainly is one of those. The cases where this is done, where the public policy argument overrides the confrontation right, it's done in cases where safety or security is involved, where Craig, perfect example, the potential trauma to children allows courts to have this sort of testimony, the closed caption testimony we saw in Craig, where the witness is out of court and is not there to be confronted. The mass cases that we've seen recently with the COVID pandemic, where courts allow testimony in masks, but only to safeguard the lives of people in the courtroom, right? And the sort of line of cases that I touched on in the beginning of this argument, Alamedi, Ketchens, and even the cases on the other side, those confrontation clause rights are balanced against the security of the witness, a desire to protect the witness. So there's some sort of physical, emotional, or mental harm that's at stake. Those are the cases that typically check the box for the public policy exception. Other than the SMAR case, which we haven't talked about yet, there's no precedent for this. There's no precedent to suggest that it's okay to balance the liberty interest, which Mr. Hancock's liberty interests were at stake here.
I agree there's no precedent for it, but I think that hurts you in a plain error analysis.
Right, and I guess
where I'm struggling.
No, I understand, Judge Easterly, and I guess all I can say in response to your question is that it is well-established law that the trial judge is supposed to conduct a factual inquiry. That's black letter law from Craig, and that wasn't done here. It just simply wasn't done.
I was going to say, let me check with Judge Ali Khan, who I think was trying to get a word in previously and was having audio issues.
Yeah, Mr. Schmidt, I was just curious, you were suggesting that the court needed to make an inquiry into the sincerity of the religious beliefs of this woman, but what do you make of the copious Supreme Court case law that says that courts are not to question the sincerity of someone's religious belief?
Well, I think if we had a case where Ms. Everhart got up on the stand and said, I wear the niqab all the time, I'm a devout practitioner of my religion, that would be one thing. I think that's probably the scenario, Judge Ali Khan, that the cases that you're referring to are contemplating. There's not much you can do with that, right? Because that is the court question, sincerity of belief. But there was doubt placed into the record by the fact that she came into the court with it, but then granted that she only wore it sometimes. So what is the reason for wearing it in this particular circumstance? And I want to note a quote from Maryland v. Craig, which I think partially gets to this issue at least, which is that face-to-face confrontation may be abridged only when there is a case-specific finding of necessity. There was no such finding here by the judge. So, I understand the sort of tension between the authority that you identified, Judge Ali Khan, and the circumstances we have here, but Mr. Hancock at least deserved, either from the court, and we haven't gotten to the 23-110 issue yet, or his lawyers, some sort of inquiry here as to our belief. Someone should have been placed on notice that this was problematic, and it was not done either at the trial level or by either by the trial court or by his counsel.
Thank you,
I
Mr.
see my
Smith.
time. I'm sorry. Go ahead, Judge Beckwith.
I guess you mentioned, did you want to take a minute to touch on something else? We will give you time.
I wanted to ask Mr. Schmidt to address the severance argument.
Yes, Judge Easley, let me just switch my notes here. I can get to that. So the trial court should have severed the defendants here, Mr. Hancock and Mr. Cook, because the two requirements that you need for severance are that there's a substantial contradiction between the defenses. And that is unquestionably the case here. I'll get into that just momentarily. And the second requirement is that it created the danger that the jury's decision was unreliable as a result of that conflict. And I think when we look at the defenses here at issue, they were clearly contradictory. Mr. Cook's defense was that he didn't do it, and as is detailed in our brief, and the government actually does it in their brief as well, there were numerous instances during the trial where Mr. Cook pointed the finger essentially at Mr. Hancock and said, either by eliciting testimony or by statements by his counsel. Now, I understand and I grant that it's not unusual, certainly, for defendants to point the finger at each other. This happens all the time in criminal trials. But when you contextualize it with the evidence that we had before us, and the evidence that Mr. Cook was eliciting and or suggesting as to Mr. Hancock, which the trial court actually, I believe, criticized at one point Mr. Cook's trial counsel for doing this. The evidence was that Mr. Cook was seen walking with a gun to the scene of the crime, and there's no direct evidence that Mr. Hancock had a gun. There's no direct evidence that Mr. Hancock actually participated in the shooting. There's some evidence that there was a struggle with Mr. Gladden, the decedent. There was some evidence, there's of course testimony from Ms. Everhart that he was at the scene, but there's no evidence that, direct evidence at least, that Mr. Hancock shot Mr. Gladden. So the net effect of this was you have two defenses which are contradictory. Mr. Hancock's defense was that he didn't do it. He didn't point any fingers at Mr. Cook. And Mr. Cook relied on sort of did a, I can't figure out how to qualify this, but a sort of trick shot defense where he said you can believe Ms. Everhart as to certain things, but you can't believe her as to other things. And I think that this situation was certainly a concern in terms of confusing the jury and leading to a circumstance where the jury is convicting Mr. Hancock for things that he is not responsible for. That's the basis of our severance argument, Your Honor. I don't know if you had a particular question, Judge Easterly.
I'll in the interest of time, we'll move on.
Okay. I see my time is up. I'm happy to deal with other things on rebuttal. I believe I have a minute for rebuttal as well.
Thank you, Mr. Schmidt. We will give you a minute or two for rebuttal, and we'll hear from Mr. Day.
Thank you.
Thank you.
Good morning. May it please the court. Sean Day on behalf of Mr. Cook. I'd like to reserve a minute as well for rebuttal. I wanted to focus on the sufficiency of the argument issue, but before I do that, I just wanted to fill in a couple blanks regarding the plain error issue on the confrontation clause. In Conley, this court said that the plainness of the error can depend on well-settled legal principles as well as well-settled legal precedents. And in Arthur, the court said trial judges are presumed to know and apply legal principles enunciated in appellate decisions and not simply match factual scenarios, as few cases present the same facts. So that allows for plain error based upon legal principles, even though we don't have a legal precedent directly on point. And I think Mr. Schmidt aptly cited Craig, which said a face-to-face confrontation may be abridged only where there's a case-specific finding of necessity. Certainly her practice of wearing niqab, she wore it sometimes, as she said, but even if she wore it all the time, you know, Mr. Cook's sitting in prison. He's got a 20-year sentence. To suggest that his right to a fair trial has to be compromised because she wants to wear a niqab to testify before a jury. There's no case law that says that your religious practice gets to trump a criminal defendant's right to a fair trial. But if I could, I'd like to move to the sufficiency of the argument, which also serves as a backdrop for the confrontation issue. Both parties were convicted solely on the testimony of Alicia Everhart. Her testimony was inherently incredible, but even if we were to accept her testimony and the pieces of it that were most favorable to the government, the proof fell short. At the time of the incident, she was high on PCP and marijuana, though like everything else, her trial testimony was conflicting. At one point at trial, in one single answer, she said she did not remember if she was high, she was probably high, she was not high. But perhaps the most compelling evidence on this point is when she was answering a question before the grand jury, which was admitted at trial, just describing what she saw, not specifically responding to a question about whether or not she was high. And she said, I don't know if Don Hancock was standing up or what, because everything was just happening so fast because I was so high. In her grand jury testimony, she admitted she was high on PCP, that it would cause her to hallucinate, to hear things that were not happening, and to make up things that were not true. Of course, before the trial, she testified that the PCP did not cause her to hallucinate. And when confronted with her grand jury testimony, pointing out that she testified to two different things, defense counsel asked her, do you know what perjury is? She said no. No, she did not know what perjury is. Though before the grand jury, she testified that she did know what perjury was. Now, we know that right after the incident, Ms. Everhart talked to numerous people in succession, including her twin sister. She's so close to her twin sister, they share a nickname, Twin. She spoke to her twin sister, to Ricardo Gladden's fiance, to Mr. Gladden's parents, and to police, never mentioning Mr. Cook. A day or two after the incident, she spoke to her sister-in-law about the incident, saying Mr. Hancock, this was the first time she identified Mr. Hancock as being involved, saying that Mr. Hancock shot Mr. Gladden, and again, not mentioning Mr. Cook. As mentioned, she testified with her face completely covered. The jury was left, regardless of whether it was error, the jury was left wanting more. They sent a jury note asking for a transcript of her trial testimony. They asked for a police report for her unrecorded police interview. She gave two police interviews. The first one was recorded, the second one was unrecorded. They wanted a police report for the second one that was unrecorded. Neither could be provided. Now, I know that finding that a witness is inherently incredible is a high bar to clear, but we can clear it in this case. She was high on PCP during the incident. PCP caused her to hallucinate. She was thoroughly impeached at various points. There's much contradictory grand jury testimony that was admitted at trial that sends her testimony in different directions. And she testified that she did not even know what perjury is. But even if we can credit her testimony, take pieces of it, the evidence was still insufficient. Ms. Everhart said she saw Mr. Cook, and when she saw him, she ran. Then she heard some gunshots. Now, the government's theory on this is that the gun Don Hancock allegedly had, which caused Mr. Gladden to say, Don, why do you have a gun? That must have been a 9mm. Now, how do they reach there? Their evidence was that they found 3 bullets in the area, a set of 2 that were from the same gun, and then another one. And I have pictures in the appendix, and you can see there were the 2 that were away from the incident. They had been run over by cars, never linked up to this incident in any way. There was one still far away from where everything happened. There is a debris field in this parking lot. This is not a well-kept parking lot. There's a debris field. And they said, okay, Our theory is that one of these bullets belonged to a gun that Mr. Gladden had in his hand, and therefore we know that Mr. Gladden had a semi-automatic 9mm pistol, and that means that the revolver bullets that killed Mr. Gladden must have been from Mr. Cook's gun. But that's pure speculation. There's no evidence that Mr. Cook fired a shot. In fact, when the government was arguing for an aiding and abetting instruction, they said, quote, there is no actual evidence of who pulled the trigger. In their brief, they said the evidence was more than sufficient to prove that Cook either shot Gladden himself or had assisted Hancock in shooting him and killing him. Alternatively stated, there was no evidence that Mr. Cook pulled a trigger at all. And if there's no evidence that he pulled a trigger, then even assuming he was there, even assuming he had a gun, on what evidence was he convicted? When he allegedly approached the scene, Gladden and Hancock were already locked in a battle. Gladden had a huge knife. There's a picture of it in the appendix. He had a huge knife. Hancock had a gun, according to Ms. Everhart's testimony. They're locked in a battle. Mr. Cook approaches the scene. She runs off. She hears shots. So what happened? What happened after she ran? We don't know. What did Mr. Cook do?
But
We don't know.
Day, didn't Ms. Everhart testify that your client approached with a revolver and the evidence showed that Mr. Gladden had been shot by a revolver?
Well, right, and that's where that's why the government was introducing evidence of these 3 9mm bullets, because they are trying to establish that the gun that Mr. Gladden had was not a revolver. But they never connected these 3 bullets to this case in any way. This is just pure speculation that Mr. Hancock had a semi-automatic pistol rather than a revolver. There's no evidence of that. It's pure speculation. So what I'm suggesting is Mr. Hancock easily could have had a revolver. Mr. Hancock easily could have shot Mr. Gladden, and Mr. Cook had nothing to do with it. It was an extreme reach to take these 3 bullets in this debris field and 1 bullet in the debris field, 2 bullets somewhere else, I'm sorry, I'm calling them bullets, 2 casings somewhere else that had been run over by cars, and saying that those were connected to Mr. Hancock. There was no evidence that they were. So yeah, that's an incredible leap that they had to make to try to establish the only revolver on the scene was in Mr. Cook's hand. They never did that. That speculation, as this court said in Swan in 2006, we draw a line between rational inference and mere speculation, and gaps in the evidence in the jury's chain of reasoning cannot be filled by conjecture, guesses, or assumptions. And that's exactly what happened here. Thank you. If there are any questions, that's all I have.
Thank you, Mr. Day, and we will give you a minute or 2 on rebuttal. Let's hear from the United States.
Thank you, Your Honor. Good morning, and may it please the court. My name is Dan Lenners, and I represent the United States. The trial court did not err, much less plainly err, in not requiring Ms. Everhart to remove her niqab before testifying in this case.
Mr. Lenners, could you move a little bit closer to the mic? I'm sorry, I've got you at 100% and you're still pretty faint.
I apologize, Your Honor. Is that better?
A little bit. Thank you.
I'll try to project to my computer. I'm saying there was no error, much less plain error, in the trial court's decision not to require Ms. Everhart to remove her niqab before testifying in this case. As Mr. Schmidt conceded, there is no direct precedent from the Supreme Court or this court that would govern that decision. In fact, the Second Circuit recognized in the Morales case that the Supreme Court has not spoken to the issue of what test to apply when a witness testifies with a light disguise, or in this case, with a facial covering. Although the defendants invoke Craig, it's not even entirely clear as a matter of constitutional law that the Craig test applies when a witness has a facial covering, as opposed to the circumstances in Craig where the defendant was not able to confront the witness face to face. Here, the face-to-face element of the confrontation clause was satisfied. Ms. Everhart testified in the same courtroom as the defendant. Her eyes were uncovered. Thus, as Justice Scalia discussed in Coy, the jury could see whether Ms. Everhart looked at the defendant or chose not to look at him, and the defendant could put his eyes on her. It's rather a different element of the confrontation clause right that was somewhat limited here, which was the jury's ability to evaluate Ms. Everhart's demeanor. There's no clear Supreme Court precedent or precedent from this court saying that you apply the Craig test under those circumstances. But even
I mean, if a witness walked into the courtroom with a paper bag over her head, don't you think the trial court would have an obligation to say, what's going on here? Why is the witness wearing a paper bag over her head? And does this comport with the defendant's right to confront this witness and the jury's ability to view this witness and evaluate this witness's testimony?
Yes, Your Honor, but a paper bag is not obviously a religious garment.
I'm not saying that it is, and I would never draw that analogy. I'm just asking what the limits of your argument are. And your argument was, it's not clear that Craig has any application when a witness physically walks into a courtroom. So witness physically walks into a courtroom, but has a paper bag over her head. And you're saying there's no duty to inquire under Craig?
What I'm saying is it's not clear that the Craig test applies. Certainly the confrontation clause is implicated, but there are different confrontation clause tests for different elements. So for example, in Maddox, the Supreme Court case from 1895, the government introduced a witness's testimony from a prior proceeding when the witness had subsequently died. Thus, the jury had no ability to evaluate that witness's demeanor whatsoever. And the Supreme Court in that case didn't apply a Craig test of saying, is there a significant governmental interest, an important governmental interest, and are the other elements of the confrontation clause satisfied? I think
it's not surprising that it didn't apply the Craig test, given that it was 100 years earlier, right? I mean,
yes, Your Honor, but again, it didn't. The point is that it's not clear what test one applies in that circumstance. Surely there is some implication for the confrontation clause, but I think as a preliminary matter on plain error or even in the 23-110 proceeding, it's not entirely clear how to evaluate this. Many courts have evaluated similar circumstances under Craig, but not all have. But even if the court thinks that's wrong and that Craig obviously applies, there is no Craig error here. Ms. Everhart, there was ample evidence of the sincerity of Ms. Everhart's religiosity other than the government's opening statement. She testified that she converted to Islam in August of 2009, that she does community work through her mosque, that she has been taking classes for 2 years in reading Arabic and how to live as a better Muslim. She testified that she'd been wearing a niqab since she converted, meaning nearly 8 years before trial. And she testifies that sometimes she wears the niqab in public.
But that seems to be the key, right? I mean, because many people practice the faith without wearing certain garments. And her testimony was sometimes on that specific issue. So what shouldn't it have been incumbent on the government to say, to elicit testimony to make clear the sometimes is whenever she's out in public, right? Or the sometimes is, encompasses situations that, involve court proceedings. But here the record is less than clear that this was something that would require her to wear this garment in a courtroom.
No, Your Honor, I don't think it was incumbent upon the government to delve further. First, it was apparent from the fact that she was wearing it there that she had made the religious decision that this was a circumstance in which she wore a niqab. And as Judge Ali Khan noted, the Supreme Court has routinely and consistently told courts not to undertake to dissect religious beliefs. And they've said repeatedly and in many contexts, we have warned courts not to presume to determine the place of a particular religious belief or religion or the plausibility of a religious claim. And second, there was no objection here. The defendants didn't object. And furthermore, when they had the opportunity in the 23-110 proceedings to adduce evidence about when and where and under what circumstances Ms. Everhart wore a niqab, they forewent that opportunity. They chose to live with the record as it exists now, which is that Ms. Everhart wears a niqab sometimes, and she chose to wear it to court. Thus, with no objection under these circumstances, it's hard to see how this was error, much less plain error, for the court to allow her to testify.
Mr. Leonard, if I may, I'd like to take you to the severance question. And my first question for you is, what is the standard? Is it Tillman? Is it Zafiro? And what do you make of our cases?
I think this court has not reconciled and has consistently declined to reconcile the Tillman sufficient independent evidence test from Zafiro's implication of a specific trial right test. The court has routinely looked at both since Zafiro was decided nearly 30 years ago. At the same time, the court has not suggested that there's any daylight between the test articulated by Zafiro and the test articulated by this court pre-Zafiro. I think under either test, the defendants cannot establish the manifest injustice required for this court to find that the trial court abused its considerable discretion.
And do you concede that the defenses are irreconcilable?
Not entirely, Your Honor. Although Cook repeatedly pointed to Ms. Everhart's statements in the immediate aftermath of the murder that Hancock and Gladden had gotten into a fight, Cook never put on additional evidence beyond that the government had already put in. Instead, he argued the government's evidence to show that he wasn't involved. And this court has said that argument is not to be considered when evaluating the irreconcilability of defenses. So in that respect, they're not irreconcilable in terms of the evidentiary test. But even if they were, this court has routinely found no abuse of discretion in declining to sever in cases where defendants explicitly point the finger at each other. In Zafiro, the defendants not only pointed the finger at each other, but took the stand and testified. There was, evidence put on. Essentially, the argument here is that Cook's attorney acted as a second prosecutor and tried to blame Hancock. And again, that's a type of argument that this court has routinely rejected when defendants challenge the trial court's failure to sever. Finally, the evidence was sufficient to convict Mr. Cook. Ms. Everhart testified that he approached the scene, shushed her, holding a revolver. The ballistics identified the bullets found in Mr. Gladden's body as coming from a revolver, and there were powder burns on his face that had a cylinder gap consistent with having been fired by a revolver. That was more than sufficient evidence to establish Cook's guilt for murder.
What do you make of your opposing counsel's point that Mr. Hancock could have had a revolver as well, which would then significantly take away any sort of aspersions we can cast on Mr. Cook?
Then Mr. Cook would be guilty of aiding and abetting a murder. He was not rushing to Mr. Hancock's aid. He was sneaking up and shushing Miss Everhart as he approached. Moreover, the entire circumstances of the murder suggested that this was something that the defendants had pre-planned. Hancock used this odd ruse to get Miss Everhart and Mr. Gladden back to this dark parking lot behind a building by making various claims about needing to get his car and needing to get his PCP from a place he had just been. And immediately upon exiting the vehicle, he assaulted Mr. Hancock, and then he assaulted Mr. Gladden, and then very shortly thereafter, Mr. Cook snuck up. So it's true that there was no evidence as to the type of gun Mr. Hancock had, nor who fired the fatal shots. But all that establishes is that the defendants, one was a principal and one was the aider and abettor, and the government properly proceeded against both defendants on those alternative theories. If there are no further questions, we would ask that the judgment of the trial court be affirmed.
Thank you, Mr. Lenners. Mr. Schmidt, we will give you a couple minutes.
Thank you, Your Honor. I want to respond to a couple of points that were made by both counsel. First of all, with regard to the evidence, I think Mr. Day suggested that there was evidence that Mr. Hancock was carrying a gun. There's no direct evidence of that in the record, Your Honor, with regard to Mr. Hancock. There's a statement by Miss Everhart where she suggests that she heard Mr. Gladden say, why you got a gun. But that evidence was also undermined by previous statements she had made. I just want to make that clear for the record. With regard to the face-to-face confrontation issue Mr. Lenners was just discussing, he mentioned the Coy case, and I want to be careful about how these issues are sort of parsed out. The Coy case, that involved a screen to protect, I believe, a child witness. And what's interesting there is that the court still did do the public policy test. In other words, while it found that there was ultimately no confrontation clause issue, it still walked through the public policy test to determine whether or not this was adequate just to override the rights to confrontation. And again, that didn't happen here. So I understand the use of Coy to suggest a former precedent with regard to being able to testify under circumstances where you can't see the witness's face at all, but you still need to have the inquiry as to whether the test is satisfied, and that simply did not happen. That's really all I have. Those are the 2 points I wanted to make, Your Honor. I didn't know if there were other questions from the panel.
Like no. Thank you, Mr. Schmidt. Mr. Day, we'll give you a couple minutes as well.
Thank you. I did want to address, point to a couple cases or draw attention to the government's cases rather, regarding whether or not the court can question the sincerity of someone's religious belief. They did cite the 2 cases, but they're really not in any way relevant to the case. One related to tax deductions that somebody was claiming for contributions to the Church of Scientology. The other was an unemployment case. Somebody was claiming that he couldn't make armaments consistent with his Jehovah's Witness religion. But again, my position is, even if she had sincere beliefs, she was not a custodian of records coming in to authenticate a document. She was the witness for the government, the witness that they needed to convict my client. And her, whatever rights she might have, cannot trump my client's rights to a fair trial in a courtroom when his life is on the line, his freedom is on the line. Now, regarding the sufficiency of the evidence, this ruse that counsel referenced, there's no evidence that Mr. Cook had anything to do with any of that. Testimony was that Mr. Hancock got in the car and led Ms. Everhart and Mr. Gladden to a nearby area to get the drugs. And then there was a commotion, and then Mr. Cook came upon the scene. Again, pure speculation that he did anything at all. Pure speculation that he pre-planned anything. Pure speculation that he fired a shot. And I know that Mr. Hancock disputes that he had a gun. For our purposes, we accept that he had a gun. The government, in closing argument and in the rebuttal argument at trial, said he had a gun. They were pushing the idea that Mr. Hancock had a gun. Ms. Everhart testified that Don Gladden's last words that she heard, Mr. Gladden's last words that she heard were, "Don, why do you have a gun?" There was no evidence whatsoever that Mr. Cook was involved in any way, even if we accept parts of her testimony that were most favorable to the government. That's all I have. Thank you.
Thank you, Mr. Day, and thank you all counsel for your briefing and your arguments today. We'll take the case under advisement, the cases, I guess, and you may exit the virtual courtroom. Thank you.
This court is now adjourned.